Hi everyone, welcome to this session on legal news update. Another Friday, another new session. Last week we discussed about Hindu imposition. Before that we discussed about reservation policy, about Dalit Christians, Dalit Muslims. This week we are going to discuss something about hate speech. Now what is this hate speech? You must have heard about in news that someone has been arrested for hate speech. So hate speech, is it only religious? What are the laws dealing in India that deal with hate speech? What are the laws that have provisions regarding hate speech? Is it defined anywhere? What are the cases, the landmark cases that have disposed of with the cases regarding hate speech? So all those issues we're going to discuss today. So let us begin this session without much ado. One second. Okay. So this article has been taken from the Indian Express, and it says that Supreme Court directions on hate speech, how courts have read IPC section 295A. IPC, as you know, is Indian Penal Code that came into force in 1860. So IPC section 295A and similar other provisions that deal with hate speech. And in the preface, it says that India does not have a formal legal framework for dealing with hate speech. So, how do we deal with hate speech? There are a set of provisions of the Indian Penal Code that are loosely defining hate speech that are invoked. So, we do not have any specific statutes, just like, say, for example, we have a specific statute like Consumer Protection Act, or we have any specific statute like, for example, the flag code, how to respect the national flag and the things regarding that. For hate speech, there is no such special act, there is no such special uh, law, there is no formal legal framework dealing with hate speech. But we do deal with hate speech in the one of the section that is mentioned is Indian Penal Code section 295A, and there are other similar provisions that we are going to discuss. So let us see what is it about. And why are we discussing it this year? What happened recently that this issue came in the news, that a Supreme Court bench comprising of Justice K.M. Joseph and Rishikesh Roy in interim directions on Friday, that is last Friday, October 21, uh, directed the police chiefs of Delhi, Uttar Pradesh and Uttarakhand to take immediate suo motu. Now suo motu word is also important, especially in CLAT and other law entrance examinations. Suo motu means on its own. That means it was not requested by the judges to order this, but they ordered this on its own. So suo motu action against any hate speech by lodging criminal cases without waiting for formal complaints. So do not wait for people to come and lodge a complaint that there has been hate speech here or hate speech there. If you hear about any hate speech being uh, any incident of hate speech, so lodge a criminal case. Do not wait for formal complaint. So you have to take immediate action that has been directed by the Supreme Court, comprising of two justices, as named. The bench was hearing a petition which called attention to the speeches delivered at Virat Hindu Sabha, organized by the Vishwa Hindu Parishad's Delhi unit and other Hindu organizations in the capital on October 10, and other similar petitions seeking actions following hate speeches against Muslim at some Dharam Sansad events. As you know that Vishwa Hindu Parishad or this Virat Hindu Sabha, these pro Hindu organizations that often uh, try to talk about one religion while not talking so much about the other religions. So in that sense, this kind of speeches, the speeches that incite hatred against one religion or anything that happens here, that has to be dealt with. And this was the issue before the court, and the court was hearing a petition regarding this only, regarding the Swiss Hindu Parishad's Delhi unit and other Hindu organizations in Delhi that have had such incidences. So the court warned authorities that any hesitation to act in accordance with the direction will be viewed as contempt of court. So if you will not, what is contempt of court? Contempt of court can be in two forms. Number one, suppose you disrespect the court, then that will be contempt of court. and you can disrespect by also not following the order of the court. So court can order anything, but if you do not follow that order, if you do not fulfill the obligations that is imposed upon you by the court's order, then you will be you will be disrespecting the court in that manner. So that also is a case of contempt of court. So if you hesitate to act in accordance with the directions, that will be viewed as contempt of court, and appropriate action shall be taken against the erring officers. So you have to lodge a complaint, take appropriate action whenever you hear any incident of hate speech, and if you fail to do that, that will be contempt of court. This is the order by the court. So that is why it came in news. Now, while India does not have a framework, formal legal framework, as you already mentioned, for dealing with hate speech, a set of provisions of the Indian Penal Code loosely defining hate speech. So it is not defined properly exactly what is exactly is the hate speech. Just like in Indian Penal Code, we have definitions for everything and very detailed definition. For example, if you talk about say theft, there is a detailed definition of what is theft, detailed definition of what is robbery, detailed definition of what is dacoity, what is every offense that is mentioned in the Indian Penal Code has a detailed definition. But hate speech is not defined as such. So loosely defining hate speech are invoked. These are primarily laws to deal with offenses against religions. So hate speech, when we use the word hate speech, we do not use the word religion specifically, but usually, as it is seen in the cases, that hate speech is towards a particular religion. You are talking ill about a particular religious belief or the religion altogether. So that is usually dealt with as mentioned section 295A. Section 295A and other sections of the section 295A defines and prescribes a punishment, what not for hate speech as such, but for deliberate and malicious acts that are intended to outrage religious feelings of any class by insulting its religion or religious belief. So it is very specific to religion. Section 295A is specifically regarding insult and the intention to insult a religion or a religious belief. And look at the exact definition that is given. Whoever, with the deliberate and malicious intention of outraging the religious feelings of any class of citizens of India, how either by words you say something ill, something bad about other religion, or it can be spoken or words. Either you speak, say in a assembly, like the case in the present petitions, where the Vishwa Hindu Parishads had a meeting, had a sabha, or it could be in the form of writing. You write a novel, you write a book, you publish it in a newspaper or in any forms of even Facebook. Recently we had this Nupur Sharma case where, in a news debate, Nupur Sharma said something about Prophet Muhammad, and action was taken against her. So by words, by or written, or by signs, or by visible representations, or otherwise. So it can be words written or spoken, or it can even be signs or any visible representation. So any disrespect, suppose you treat an idol, a religious idol, disrespectfully by any sign, by any, there can be so many examples, so you can think of any. So if you do any of that, it will come under that. So either you insult or attempt to insult, not only committing the act, but also the attempt to commit the act is punishable. Attempts to insult the religion or the religious beliefs of the class shall be punished with imprisonment of either description for a term which may extend to 3 years, or with fine, or with both. So it's punishable offense. 3 years imprisonment can be given if you do any of these. So any person who is writing anything on Facebook, any person tweeting it, any person writing a book about it, or distributing a pamphlet about it, or any form of words spoken, written, sign, visible representation, any form you either insult or even you attempt to insult the religion or religious belief of other people, class of citizens, the word has been used, then you will be punished. That is your section 295A. Then section 295A is one of the main provisions in the IPC chapter to penalize religious offenses. Penalize means to punish. The chapter includes offenses to penalize damage or defilement of place of worship with intent to insult the religion. So we have section 295 that talk about defilement of a place of worship. So suppose there is a temple or there is a mosque, and you defile that place, you do something that is not expected there. Or suppose trespassing in a place of sepulture. What is sepulture? You must have seen the graveyards where the dead bodies are buried. So if you suppose do anything in the graveyards, in the sepulture, so trespass in the sepulture. So you must have seen in every city these are gated graveyards, gated sepultures, or even the place where the dead bodies are being burnt or bodies are being buried. So if you go there, you trespass there, unauthorized, you enter that property in an unauthorized manner, or do something that is not expected there, uttering words, etc., with deliberate intent to wound the religious feelings of any person. This was something that I just mentioned Nupur Sharma case. So uttering words, etc., with the deliberate intent to wound the religious feelings of any person, and disturbing a religious assembly, or if there is an assembly going on, you go and disturb that. So different sections are there: section 295, 297, 298, and 296. These are the sections that deal with uh, people who are trying to incite uh, hatred against another religion, or and if you will notice, all of these are very religion specific. So section 295A is very religion specific. So that is covered mostly in hate speech. The state often invokes section 295A along with section 153A. We have another section 153A. What does it do? It penalizes promoting enmity between different groups on grounds of religion, race, place of birth, residence, language, etc. So 153A has a wider application. 295A is only regarding religion, place of worship, even sepulture, uttering words regarding religious feelings, disturbing a religious ceremonies, religious assembly. But 153A takes into account a lot of things, including race. Suppose you are spreading hatred against someone's race, or place of birth, someone born in a particular geographical location, and you say something against the people belonging to that place, or residence, or language. So such a wide parameters are used in section 153A. Doing acts prejudicial to maintenance of harmony. And then another section is there, section 505 of the Indian Penal Code, that punishes statements conducing to public mischief. Public mischief. So, if you will read the Indian Penal Code, you will read about mischief. What is mischief? And also, it has been asked in CLAT several times regarding, because mischief itself is an offense. So, when you destroy a property, not with the intent to gain something out of it, but just for destroying it, so that destruction of property is mischief. So, that can be public mischief. So, that is section 505. Then we also have the IT Act. Section 66A of the Information Technology Act punishes sending offensive messages through communication services is added when such speech is made online. So suppose again I will talk about the recent case. That's why I've been mentioning it again and again. That happened in Nupur Sharma case, or when following the Nupur Sharma case, there was an incident where uh, a person killed a tailor and then recorded a video about it and uploaded it on online. So if you are making the speech online, suppose on Facebook, on YouTube, or even writing on Facebook, so that will be dealt with section 66A of the Information Technology Act. So all these sections we use specifically to tackle hate speech. The broad weight terms in the laws are often invoked in this misuse. So the broad and vague terms, you will see that such a broad and vague terms, uttering words etc. with deliberate intended to wound the religious feelings. Now, how does a religious feeling get wounded? It's a very broad term, it's a very vague term. There can be sensitive people, there can be people who are not so sensitive. So depending on the whether it's a normal person or it is someone that uh, takes the religion so seriously, depending on all those factors we have to take into account all that. Uh, so in this we have to see that whether the terms are defined in a proper manner, in a specific manner, in a manner that can be interpreted strictly, or they have been defined very broadly, very vaguely. So that exactly is mentioned here, that the broad and vague terms in the laws, and they are invoked in its misuse. So there is a misuse of these laws. So all the sections that we discussed, be it section 295, be it section 297, 298, 296. So all these sections can be misused because the words that are used in these sections are very broad, very vague, including section 153A and section 66A. So the words that are used are very broad, very vague. It can be misused. uh, Lower conviction rates for these provisions indicate that the process where a police officer can arrest without a warrant. Now, lower conviction rates, the conviction rate is lower. So, if someone is, say, accused of spreading hate speech, he can be arrested by the police, but he will not be convicted by the court. So the conviction rate is very lower. So exact data is not given here, but say for example, if 100 people are being accused of hate speech, maybe five of them get convicted. So it's the this is this just to show how low the conviction rate is. And lower conviction rate is, what does it mean? It means that the law is being misused. That if anybody is saying anything, and if it one person does not like it, he's misusing that law, using those broad and vague terms, making that person uncomfortable, initiating a proceeding against that person. That person has to go through the hassle of the court proceedings and the police procedures, and finally he is not convicted by the court of law. That means he was not guilty, he just was the victim of the system. So, so low conviction rates for these provisions indicate that the process where a police officer can arrest without warrant. So the police can arrest without warrant. So if someone, suppose you write something on Facebook, or you say something like, I'm recording this video and someone has objection with this video. So the police comes and arrest me without any warrant, and I have to go through the police proceedings and the court proceedings, and ultimately maybe I am not convicted. So I will have to go through all that trouble. So this shows that the law is being misused. Critics have pointed out that these laws are intended for the state to step in and restore public order rather than protect free speech. So the critics of these the lack of legal framework in uh, this in India regarding hate speech, they have said that it's to protect public order. If everybody will say, offend everyone, of course there will be public disorder. So we need these laws. We need these laws in order to have a public order, but and also we have the freedom of speech and expression that are subject to reasonable restrictions. So we are not here to protect free speech, that anybody can say anything, but we are here to provide a public order so that people do not offend each other based on religious belief, or based on the wider section that we talked about regarding race, place of birth, residence, language, etc. So section 295 was brought in 1927. So it's a very old section. 1927. Do you understand this? It's the Britishers era before independence. In his book, Offend, Shock, or Disturb, lawyer Gautam Bhatia writes that the antecedents of section 295A lie in the communally charged atmosphere of North India in the 1920s. So why was there a need for section 295A? Because it was brought in 1927. So in the 1920s, the North India was communally charged. There was an atmosphere where there was a some problem between Hindus, Muslims. So it was communally charged environment. That's why this section had to come. The amendment was a fallout of an acquittal under Section 153A of the IPC by the Lahore High Court in 1927. So we already had Section 153A, which was wider, which was about language, residence, place of birth, everything. But under that section, there have been an acquittal, not conviction. As I told you, there are low conviction rates. There was an acquittal under Section 153A of the IPC by the Lahore High Court. Since we're talking about 1920s, we had a Lahore High Court in Rajpal versus Emperor, popularly known as the Rangila Rasool case. So there was this case called Rajpal versus Emperor, and this is popularly known as Rangila Rasool case. And you must have guessed, if not, that this is a this case was regarding Prophet Muhammad. And let's see what the case was. Then the Rangila Rasool case, it was a tract is a, say, a pamphlet that is usually of religious nature, that is distributed. So this was a tract that is brought out by a Hindu publisher that had made disparaging remarks about Prophet's private life, Prophet Muhammad's private life. He made some disparaging remarks. Cases against the first pamphlet, filed under Section 153A, were dismissed by the Punjab and Haryana High Court, which examined the question whether targeting religious figures is different from targeting religion. So, Section 153A is regarding, suppose I'm talking ill about you, a person's religion, but if I'm talking about a person's religious figure, is that also covered under the same section? This question was being considered, and this case was dismissed when the first pamphlet was published. But when a second similar piece was published, it raised tensions. So of course, once it was dismissed, but when second time it happened, there were tensions. While the magistrate had convicted the publisher Rajpal under Section 153A, the Lahore High Court held that a scurrilous and foul attack on a religious leader would prima facie fall under Section 153A, although not every criticism. So, every criticism will not fall under Section 153A, only very serious and very demeaning, very foul attack, that will fall under that. So this debate and interpretation prompted the colonial government to enact Section 295A with a wider scope to address these issues. So that is why in 1927, Section 295A was included to have with a wider scope to address these issues. So wider in the sense that wider in it got more into the religious aspect of it. 153A was wider in the sense that it included things other than religion. It included race, language, place of birth, etc. And 295A got very specific regarding the religion, religious figures. So that's how we felt the need for Section 295A. Then after that, after this infamous Rangila Rasool case, we had later cases. 1957, the constitutionality of Section 295A was challenged. There was this case called Ramchilal Modi versus State of Uttar Pradesh. The Supreme Court upheld the law on the grounds that it was brought in to preserve public order, as we have already discussed. That what was the need for Section 295A? To have a public order, because when everybody will start offending each other, there will be public disorder, as we have seen in so many cases, even in the latest developments in India itself. So, public order is an exception to the fundamental right to freedom of speech and expression and the right to religion recognized by the Constitution. We have Article 19(1)(a) that gives us freedom of speech and expression. But we also have Article 19 Clause 2. 19 Clause 2 talks about the reasonable restrictions that can be imposed. So you are free to express anything that you want. You can write anything on Facebook, you can tweet anything, you can do whatever you want. But there are reasonable restrictions to it. It's not that you can do as per your whims and fancies, not keeping regard of national integrity, unity, or security of the nation, or offending anyone, or there is any what do we call it, defaming. There is a there can be a case of defamation against you. So all these factors you have to take into consideration. There are reasonable restrictions to your speech and expression. In a 1960 ruling in Baba Khalid Ahmad versus State of UP, the Supreme Court said that malicious intent, malice means ill will, malicious intent of the accused can be determined not just from the speech in question but also from external sources. So, this is also very important to understand that malicious intent of the accused can, how do you determine that? Not just from the speech in question, the speech that he gave, was it full of malice? It can be also from external sources, from, say, for example, his previous conduct, how he has been presenting himself in public regarding his opinion about other religions and what other people say about him. So that is also relevant. So that can also be taken into consideration. In 1973, in Ramlal Puri versus State of Madhya Pradesh, the Supreme Court said that the test to be applied is whether the speech in question offends the ordinary man of common sense and not the hypersensitive man. This I have discussed this in today's session only, that the person, when we are talking about that who gets offended, there can be people who can be easily offended. So we are not talking about hypersensitive man, we are talking about ordinary man of common sense, that okay, yes, you may be religious, you may not be religious, but do you have the sense to at least not be disrespectful or not get offended by things that may not be offensive in ordinary sense. So however, these determinations are made by court, and the distinctions can often be vague and vary from one judge to the or the other, one judge to the other. So obviously, I mean, different judges, different judgments, different opinions. The last case in Barakpur, Ramachandrappa versus State of Karnataka, 2007 decision of the Supreme Court. A pragmatic approach was invoked in interpreting Section 295A. The state government had issued a notification banning Dharma Karan, a Kannada novel written by award-winning author P.V. Narayan, on the ground that it was a hate speech, invoking a gamut of provisions including Section 295A. The pragmatic means practical. So the practical approach was that how to restore public order. You forfeit the book and do not, over the individual interest of free speech. So if you have to choose between public order and free speech, of course you will choose public order. So practically speaking, you can forfeit the book, you can say ban the book, stop its publication, not let it reach the hands where there can be public disorder because of that book. So that practical approach was taken in this case. So that is how the hate speech we have been dealing in India. There is no specific definition that defines hate speech, that tells us that okay, this is hate speech and this is not hate speech. But we have several provisions as we saw in this session. Section 295A, most importantly, that was inserted in 1927, and in 1920s was the era we discussed about the cases from the 1920s, 1950s, 1970s, and latest 2007, and also the latest developments regarding so many things that we hear in news every other day. And of course this particular discussion is happening because of recent Supreme Court directions to Delhi, UP and Uttarakhand regarding if any hate speech is being uh, anybody is involved in this, we should take immediate action. And if you fail to fulfill this order of the court, there will be a contempt of court. So this was about hate speech. Hope you learned a thing or two, and you know that it's not defined, but there are several provisions in the uh, IPC, in the Indian Penal Code, in the IT Act, and several other forms of provisions that provide certain safeguards regarding hate speech in India. So thank you so much. See you in the next session with yet another session. Till then, have a good day.